Good morning and welcome to Law Talks here on 4CRB. Well, there's been a lot of noise about the changes to negative gearing and capital gains tax following the 2026-27 federal budget. Many Australians are wondering what these changes mean if they already own property, are thinking about investing or are considering changing the way they own their property. To help us unpack it all, we're joined by Attwood Marshall Lawyers, Property and Commercial Law Senior Associate Mieke Elzer. Mieke, thank you for joining us this morning.
Hi, Robyn. Thanks for having me.
Well, we've heard a lot about these tax changes. At a high level, what are the main changes people need to know about?
Well, there certainly has been a lot of discussion, hasn't there? And that's because for many Australians, their home or investment property is their biggest financial asset. It's understandable that people want to know what these reforms mean for them. The reforms have also changed the way many investors will approach buying property in the future. In broad terms, the reforms are designed to encourage investment into new housing, which should in turn create more housing stock, as well as make buying an existing property more accessible for first home buyers and people looking to purchase a home to live in. The reforms mean the tax treatment of some investment properties has changed, particularly for people looking to purchase established residential properties. There have also been significant changes to the way capital gains are taxed when certain investment properties are eventually sold. From my perspective, anyone thinking about buying or investing in property should obtain advice before they sign a contract.
Yeah, there's a lot of moving parts rather than just one significant change for people to wrap their head around. So, Mieke, there has been so much commentary about these reforms. Can you explain in simple terms who wins, who is protected and who is most affected?
Well, that seems to be the question everyone's asking. The first thing I'd say is that existing property owners shouldn't panic. One of the key features of these reforms is that they've largely protected people who have already made investment decisions before the changes were announced. So if you owned an established residential investment property before 7:30 p.m. on 12th of May 2026, or you'd already exchanged contracts at that time, those investments have been grandfathered in relation to the negative gearing reforms. In other words, the existing negative gearing arrangements continue to apply to those properties unless and until they're sold. The biggest change is really for people looking to buy an established residential investment property moving forward. For those properties, negative gearing will generally no longer be available, meaning any losses the property makes will not reduce your salary or other personal income. Instead, those losses are carried forward and can generally only be applied against residential property income or capital gains. Because the government's policy objective is to encourage investment that genuinely increases housing supply, investors purchasing eligible new builds will continue to have access to negative gearing. And they'll also have a choice of capital gains tax treatment when they eventually sell.
And can you explain the transition rules? These rules seem to be where many people become confused.
Absolutely. Those reforms don't operate with a simple before and after rule, so it's completely understandable that people would be confused. So with respect to the negative gearing reforms, residential investment properties owned at the time of the announcement, including those under contract but not yet settled, will continue to be negatively geared until they are sold. Properties purchased after the announcement but before 1 July 2027 can be negatively geared only until 30 June 2027.
Okay.
From 1 July 2027, losses on those properties will no longer be negatively geared. And residential investment properties purchased on or after 1 July 2027 will not be eligible for negative gearing treatment.
So what about people who already own investment properties? Should they be rushing to sell before these changes take effect?
Not necessarily. In fact, for many existing investors, the legislation includes grandfathering provisions designed to preserve the tax treatment of investments that were already owned. That's why I'd be cautious against making decisions based purely on media commentary. Every person's circumstances are different, and selling property can have significant legal and taxation consequences. Before making any major decisions, it's worth obtaining advice so you understand how these reforms will actually apply to your situation.
And who should be paying attention to these changes? Is it really just property investors?
Investors are certainly one group, but they're far from the only people who should be paying attention. These changes could also affect people buying a holiday home, parents helping children into the property market, or even adult children purchasing property with financial assistance from their parents. Whenever you're buying property or changing who owns it, there can be legal, tax and stamp duty consequences. Property is often someone's biggest financial asset, so even if you don't think of yourself as an investor, it's worth understanding how these reforms fit into your long-term plans.
Yeah, absolutely. And we've talked about buying property. What about people thinking they should move properties into trusts or companies because of these reforms?
That's something we've already started to see, and some people assume they can simply transfer property into a trust or company once the rules change. But a transfer isn't just an administrative exercise. It can trigger stamp duty, capital gains tax and other legal consequences, even where the property stays within the family. In some cases, trying to fix the ownership structure afterwards can actually become more expensive than getting it right in the first place.
Well, we've focused on investors, but could these reforms also affect ordinary families dealing with, say, separation, succession planning or deceased estates?
Oh, absolutely. Property isn't only bought and sold, it's transferred between spouses after separation, inherited through deceased estates and often passed between generations as part of succession planning. When ownership changes, there can be legal, taxation and stamp duty consequences.
So what are the biggest mistakes you're seeing people make at the moment?
The biggest mistake is reacting emotionally. Property decisions should be driven by your long-term goals, not headlines and fear of missing out. So recently acted for a client who rushed into signing a contract because they were worried about the reforms. Unfortunately, they signed before the ownership structure had been properly established, and we then had to negotiate with the seller to unwind the contract and start again. Look, thankfully we had a good outcome, but it was stressful, expensive and completely avoidable. That's why I'd always say get advice before you sign, not afterwards. Another common mistake is assuming ownership can be changed after if circumstances change. So in reality, spending a little time up front obtaining advice before you sign can save thousands of dollars.
And when should someone speak to a property lawyer, and when should they also involve their accountant?
Ideally before they commit to buying, selling or transferring. While an accountant focuses on the taxation consequences and how the transaction fits within your broader financial position, your property lawyer is looking at different but equally important issues such as ownership structure, contract terms, stamp duty implications and whether the transaction has been documented correctly. Getting both legal and accounting advice before you sign gives you the best chance of avoiding costly mistakes.
Well, thank you, Mieke. That's really helpful information. Clearly, there's a lot of detail in these reforms, but for most people, it's not something to make a quick decision on, as you've spoken about, and particularly without the proper advice. Appreciate your time today.
Thanks so much for having me.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.